Okay, so we are good.
Correct. You are good to go.
Thank you.
Okay. Good morning and welcome to the June 13th, Friday the 13th, New York State Commission on Forensic Science meeting. Today we have sites in both New York City and Albany. As I am attending remotely, I will have OFS Director Shelley Palmer run today's meeting.
Thank you, Commissioner. At this time, I'll take attendance to establish a quorum. Please respond present when I call your name. Lieutenant Colonel Banbury. Albany, are you muted?
We're unmuted. Sorry.
Yes. Thank you. Dr. Buffalino.
Present.
Dr. Chithlin.
Present.
Ms. DeCastro.
Present.
Mr. Epstein.
Present.
Mr. Fitzpatrick.
Present.
Ms. Goldthwait.
Present.
Dr. Marciano.
Present.
Ms. Murphy.
Present.
Ms. Roush.
Present.
Ms. Schmidt.
Present.
And Dr. Willie is unable to join us today. So with that, and including Commissioner Rosado, we have established a quorum. First item of business is to review our agenda. Everyone's received the most updated version of the agenda for today's meeting. Any discussion regarding the agenda?
Yes, I think so. Is this if I want to add something? Sorry. If I want to add something, I do.
Pop up your mic. Yep.
There we go. Sorry. Thank you, Pat. If I want to add something to the agenda, I do it now. Is that right?
Yeah. Yep. If you want to make an amendment. Yep.
Yeah. So I would move to make an amendment to add the Qiagen issue. For anyone who doesn't know, earlier this year, some laboratory customers of Qiagen, which is one of the nation's biggest, I guess, supplier of DNA laboratory supplies, equipment, reagents, et cetera, reported that they were getting lower than expected DNA yields, which they reported to the company. The company then sent a customer letter to its lab customers. So I think we should know if New York state laboratories are affected and what the New York labs are doing to determine if they're affected.
Where's this company out of?
Good question. Anyone know where Qiagen is?
Headquarters,
Germany.
So we don't know collectively whether New York uses this company.
I think they do.
No, we do.
Yeah.
Our representative here, I believe, is.
Guys, can you please pop your mics up?
Oh, there.
Oh, that's right.
Like was said, it's an overseas company, but they have representation here, so it's whatever you need from them. But they did put out a technical note on the issue, so it will affect some labs, not others, because it's a particular buffer. Some labs use it, some labs don't in their extraction method. So,
Well, what I would suggest, Jessica, was agreeable to you, is rather than like have a 2-hour discussion about it, we just make a motion right now. Who uses Qiagen? What's the effect? How serious is this problem? And et cetera, et cetera.
Yeah, fantastic.
Yeah.
Could I just add to that? I think this take me a while. I think this might be a question for the members of the BioTwig. So perhaps we kind of throw it their way and find out they're the technical experts in this area. Maybe
For the next meeting.
Yeah, that would be good.
Makes sense.
Because I'm not, as the NICLAC chair, I'm not sure which labs are affected and which aren't, but that group, as the technical experts, would know. So they would be the ones that should be able to weigh in on this.
Yeah, good idea.
Is this also something for the DNA subcommittee to make sure that they're on top of?
Do we need to amend the agenda to have this? Because it sounds like we're asking to task. So Jessica's initial ask was
to amend the agenda. I think technically we're supposed to approve the agenda before we get in any business.
Yeah.
So if there's is there a motion to amend the agenda to discuss the
Yes.
And we'll put it in the new business section.
Great.
Okay.
The second.
Is there a second?
I'll second.
Okay. So with that then, I have a motion to accept the agenda with the amendment regarding Qiagen to new business and a second. All in favor, please say aye.
Aye.
Anyone opposed? Any abstentions? Okay, so with that, we will approve the agenda. The motion carries. Next, the review and approval of the draft minutes from the March 14th meeting. Are there any questions or comments regarding those minutes? Hearing none, is there a motion to approve those minutes?
Second.
All in favor?
Aye.
Aye. Anyone opposed? Any abstentions? Okay, thank you. Next item is executive session. Do I have a motion to go into executive session to discuss matters related to a current investigation or matters that lead to the appointment, promotion, demotion, discipline, or suspension of a particular person?
Would this be a appropriate time to raise an issue concerning it, or would that be after the motion is made for discussion?
I think if your issue is to whether we should be going into executive session, I think you may raise it now.
For a portion, my concern is that a portion of the materials seem to concern an individual who's no longer employed. So that seems that the discussion that we're intending to have in executive session is not concerning current employment. The individual's left the employment.
I mean, the relevant section I have here, I guess, would be 1F of 105 Public Officers Law, the medical, financial, credit, or employment history of a particular person or corporation or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. That would be the section we'd be moving into executive session based on. I guess it is up to you to determine whether what we're going to discuss fits within that.
Can you reread the first portion concerning the financial information?
The medical, financial, credit, or employment history of a particular person or corporation, or matters leading to the appointment, employment, promotion, demotion, discipline, suspension, dismissal, or removal of a particular person or corporation. I will say, at least within that statutory language, it doesn't refer to whether it's a current or former employee.
Well, it doesn't. I think it affects current employees because it deals with matters affecting their employment, but the section on financial might be applicable. It's a little overbroad, though.
But that's a permissive section, right? Like even if we do decide to go into executive session for that stated purpose, we aren't required to do so. Is that right?
That's correct.
And we could also discuss in executive session whether or not certain information is then taken out of executive session and brought to the public.
I think that would be appropriate.
Under those conditions, I would have no objection to it. But
And I'll move to go into executive session.
Is there a second? Okay. All in favor, please say aye.
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 Anyone opposed?
Yes, I'm opposed.
Any abstentions?
I'm going to abstain.
With that, we have the motion carries. So at this point, if you're not a commission member or staff, you will be expelled from the virtual meeting and streaming will be paused. The stream will resume when executive session has ended.
They can even do anything with it. It's so high up in S1.
We do.
Wait,
But it's sometimes hard to
years when
find
you're on a
because
flight,
they
on a
don't
ramp.
UCC.
Yeah, I was 40.
I'm
still riding that.
address, and you should not.
I didn't mature until
You were
52, 53.
For.
And you fell off or you
I
had a bike
can't
accident?
remember.
I got pulled up the road.
But it's, you should make fun of them.
Probably about 6.
You muted him. Yeah. Instead of, I was like, did somebody just shush them? It worked. Whoever it is. Let's start.
Sheila will join us when she's. Okay. Welcome. We're back in open session and Mr. Fitzpatrick.
Yes, two motions. The first motion is that the reason for this that came about, without mentioning any specifics, in executive session, the commission was discussing an issue regarding to what is clearly misconduct by a lab worker. And we became, as a commission, concerned that the duties and obligations of each and every lab director needs to be specified as to disclosure regarding that misconduct. And we're not talking about minor infractions, showing up late for work, other things that relate to a person's employment, but we're talking about things that intrinsically and unequivocally relate to the person's honesty. So at the suggestion of Commissioner Epstein, I propose that we draft a letter that I will draft initially to be directed to each lab director, reminding them, and maybe for the first time informing them, that disclosure of dishonesty needs to be immediate, not that day, but it needs to be done with efficiency and alacrity, and does not necessarily only come into play when the analyst in question appears in a courtroom testifying. That there's much more to the criminal justice system than testimony and trials. And that letter be then reviewed by Commissioner Epstein, and then finally, after he and I agree on changes, to be reviewed by our counsel, Matt Schranz. And that the letter be directed to each and every lab director in the state and copied to all 62 elected DAs. Have I said that right?
Yes.
Okay, so that's my motion.
Is there a second for that motion?
Second.
Okay, all in favor, please say aye.
Aye.
Anyone opposed? Any abstentions? Thank you.
The second motion I'd like to make also regards a letter, and I'm not going to mention any names, but in executive session, as a result of an anonymous complaint that was received some time ago, the commission made an effort to obtain certain documents from the Office of the Chief Medical Examiner in New York City. It was not a request made in haste or without deliberation, and it's a request that goes directly to our responsibility of oversight regarding the management of that lab and the other 24 public laboratories in the state of New York. As a result of that request, we received a letter on April the 29th of this year directed to Commissioner Rosato from Counsel for OCME, and the relevant portion of that is in the end of paragraph 3, wherein counsel writes, quote, "Without the opportunity to review the complaint, Office of Chief Medical Examiner is unable to determine the relevance of this additional information or whether it can be released." And it goes on, and I won't read that part. "For these reasons, Office of Chief Medical Examiner respectfully declines to provide the additional information." Number one, we do not release anonymous complaints. We do that for the very simple reason that we want to encourage people to feel comfortable in coming forward to this commission with anonymous complaints. I've been on the commission for close to 2 decades and have reviewed literally dozens of these anonymous complaints, some of which have led to very serious improvements regarding laboratories in the state of New York. I would never want to be party to an institution that is going to make these public. The second thing I'd like to point out, it is not, with all due respect, counsel's purview to determine relevance. It is ours. There is no question that these documents are relevant to our investigation. That letter of April 29th, after conversations between counsel for DCJS and OCME, resulted in a June 11th letter where some documents were provided regarding various commissions that the individual in question sat on. They are completely irrelevant to our inquiry. The June 11th letter reaffirmed ACME's position that they are not going to turn over these documents. I suggest, or I make a motion now that our counsel, Mr. Schranz, write one final letter to the Office of the Chief Medical Examiner demanding the document in question and indicating that if the document is not provided, that this commission will take legal action as soon as possible to compel that, probably by way of Article 78. And I
I'm
would
not sure
also
that we
point,
went that far.
I'm sorry?
Request.
We were gonna
Yeah.
do a request.
I'd also point out the obvious that, and I don't make threats, I state facts. The obvious being that this commission determines whether or not this laboratory is accredited, and that if these documents are not provided, that it raises in this commissioner's mind a serious question regarding the management style of that institution and whether or not accreditation should be continued. That's my motion.
Second.
In Albany, was there a question?
Was there a comment in
Yeah.
Albany?
Yes. Yeah, I believe that our discussion, we were gonna make a second or another request for additional information, with a more targeted description of the information we were asking for.
Well, that's my motion, to make a final request for that.
Right. And not that the letter
I-
would include a statement about possible litigation.
I'm sorry, what was,
The letter, the correspondence would not include information about potential litigation.
are you asking me to remove that from the letter? Because then the letter has no point.
We also did ask in the prior letter for information about outside in our letter to them about information about outside employment. I believe our letter was phrased clearly, to be honest, the last time around.
Yeah,
I don't think it's
there's no,
inappropriate now to underscore that this isn't gonna go back and forth for years.
there's no ambiguity about what we were asking for.
It's, when we were discussing bringing this into open session, the final part of your statement wasn't stated.
Yeah, all right,
So-
leave my, that was my personal
Okay,
opinion.
because I
Leave that
want to
out
make
of,
sure that
that,
that's separate from what it is that
that
we're
doesn't need to go
asking
into the
for,
letter.
please.
My letter, the substance of my letter is, give us the information. We're very specific about what we're looking for. You do not make determinations about relevance. We do. This is clearly relevant to our statutory obligation of regulation of OCME, and that it has to contain language that if you fail to deliver this information, our only other opportunities for litigation.
So there's a motion on the table with a second.
I second the amended language as proposed by Commissioner Fitzpatrick.
Mr. Epstein seconds the amendment. Call for a vote. All in favor, please say aye.
Aye.
Anyone opposed? And any abstentions?
Aye.
One abstention in Albany.
One abstention only. Thank you. With that, the motion carries. There are no further actions taken in executive session. Okay. Before we move forward into laboratory updates, I'd like to provide a little information regarding some language changes you may have noticed when you were reviewing your documents from A&AB. A&AB conducts various assessment activities, both virtual and in person, during an assessment cycle. The virtual activities were previously called surveillance document reviews, and they'll now be called surveillance assessments without witnessing. So some of the documents you may have seen have old language, some have new language. It depends on the date that we received them. On-site activities have been previously called surveillance assessments, and they will now be called surveillance assessment with witnessing. The type of activity performed can be found in the activity plan and the assessment report provided by A&B following each activity. And they're hoping to make a complete transition to this language by September, so you see some more carryover between the different styles of documents. So with that, we'll jump right in. We have quite a few labs here. Just to preset, most of these are for informational purposes only. There will be one vote today, and it happens to be the last lab. Okay. So first up, we have Erie County Central Police Services Forensic Laboratory. In April, A&AB conducted a surveillance assessment activity and there were no findings. They have issued a continuation of accreditation based on the results of this activity. Any questions for the laboratory? Okay. Erie County Medical Examiner's Office, Forensic Toxicology Laboratory. In April, A&AB conducted their surveillance assessment activity and there were no findings. They have issued a continuation of accreditation based on those results. Any questions for that laboratory? All right, Monroe County Crime Laboratory, also in April, received a surveillance assessment activity with no findings. The laboratory is awaiting for their final documents from A&AB, so they will be again on the agenda in September. Any questions regarding that? Monroe County Office of the Medical Examiner Forensic Toxicology Laboratory. In March, A&AB conducted a surveillance assessment activity with no findings, and they have issued their continuation of accreditation. Any questions for that laboratory? The Nassau County Office of the Medical Examiner's Division of Forensic Toxicology received their surveillance assessment activity in March, also with no findings, and A&AB has issued their continuation of accreditation. Questions for that lab? Okay. Up next, the New York City Office of the Chief Medical Examiner, Department of Forensic Biology. DCJS and A&AB have both been notified that Dr. Craig O'Connor has been appointed as the Forensic Biology Director Designate. Dr. O'Connor's CV has been provided for review. Dr. O'Connor is here today. If there's any questions.
Congratulations.
Congratulations.
Yes.
The New York City Office of Chief Medical Examiner, Department of Forensic Toxicology. In April, A&AB conducted a surveillance assessment activity. There were no findings. During this activity, the scope was updated to remove ultraviolet spectroscopy from qualitative determination and quantitative measurement, and to remove mass spectrometry from qualitative determination of volatiles. A&AB has issued a continuation of accreditation based on the results of the assessment activity. Any questions for the laboratory? The New York City Office of Chief Medical Examiner Forensic Anthropology Unit. The lab has been in contact with A&AB following their November 2024 assessment activity regarding several updates to their scope document. An administrative error was detected by the laboratory and an update to key equipment technology was requested. The updated scope was received by the laboratory and verified as accurate. The laboratory has also notified both A&AB and DCJS of a change in management. Dr. Brad Adams retired and Dr. Angela Solar has been selected as the Forensic Anthropology Director Designate. Dr. Solar's CV is provided for your review. Unfortunately, there's no lab representatives available, so if you do have any questions, we can revisit these items in September. Or if we're good, we'll just say congratulations to Dr.
Congratulations.
Congratulations.
To both. Retirement and the new job.
Yes. All right, the New York State Police Crime Laboratory. Laboratory has notified A&AB and DCJS that Brad Brown, the previous Associate Director of the Physical Comparison Unit, retired on April 23rd. Any questions regarding that retirement? Okay. The Niagara County Sheriff's Office Forensic Laboratory in February received surveillance assessment and document review by A&AB. There were no findings. The assessment report and activity plan were provided and reviewed at the March meeting. In this material, you have the continuation of accreditation letter based on that activity. Any questions for the laboratory? Okay. Onondaga County Medical Examiner's Office of Forensic Toxicology. In April, A&AB conducted a surveillance assessment activity and there were no findings. A&AB has issued a continuation of accreditation based on the results of the assessment activity. Any questions for the laboratory? Suffolk County Medical Examiner Toxicology Laboratory. In March, A&AB conducted a surveillance assessment activity and there were no findings, and they have issued a continuation of accreditation based on this activity. Any questions for this lab? Westchester County Department of Labs and Research Forensic Toxicology. In March, A&AB conducted a surveillance assessment activity with no findings. During this activity, mass spectrometry was removed from qualitative determination of volatiles. ANAB has issued a continuation of accreditation based on the results of the activity. Any questions for this lab? And then finally, we have Yonkers Police Department Forensic Science Laboratory. In May, the lab underwent a full reassessment by ANAB, and there were no findings. During the reassessment, the laboratory scope was updated in seized drugs to remove the item gas under qualitative determination. ANAB has granted full renewal of accreditation based on the results of this activity. Are there any questions for the laboratory?
I have one question.
Absolutely. We have the laboratory director virtually, so if you could, Christina, if you could turn your camera on and join us. Thank you. All set? Oh,
Can you hear us okay?
we can't hear you.
Yeah, we can't hear you. I think you might be muted.
Yep, definitely muted. Can you hear me now?
Yeah, I can. Thank
Okay,
you. This is
thanks.
Erin Murphy. I just wanted to ask, when you do reports on latents, do you individualize? Do the analysts say that this is this person's fingerprint?
No, we only do development. So we will photograph ridge detail that is suitable for capture. And then those photographs go somewhere else for comparison.
Okay, great. Thank you so much.
Welcome.
Any other questions for the lab director? Okay. With that, is there a motion to issue full renewal of the New York State accreditation to the Yonkers Police Department Forensic Science Laboratory concurrent with its ANAB accreditation? Motion by Ms. Schmitz. Second?
Second.
Second by Dr. Buffalino. All in favor, please say aye.
Aye.
Anyone opposed? And any abstentions? Thank you. With that, the motion carries, and congratulations.
Thank you.
Okay. Up next, old business.
Shelley, can I just say something quick? Very impressed with all the labs, no findings. There were, I mean, this was the majority of the labs in the state, it feels like, and that was very
Nice
impressive.
review.
Yeah.
We're able to fly.
Agreed.
That's it. Material is much easier to go through.
2025 is a good year. Okay, so the first item of old business is the familial search update. So I'm just pulling up the numbers so I can provide you. Changes since our March meeting. There's been 3 new applications received, all initial applications. There have been 6 applications approved and 4 searches completed, all contained no results. So the total now stands for the program, 74 applications in total, 58 initial, 8 renewals, and 8 resubmissions. With 57 approved, 3 withdrawn, 13 rejected, and 1 in review stage pending additional information. Of the 57 approved, there are 12 in the search queue. 45 searches have been completed, 34 no results, releasable results, 11 with results released, 6 investigations ongoing, and 11 investigations closed. Updates from the subcommittee. So just to provide a quick status update on the work that the subcommittee has been doing. At their May meeting, they did discuss their subgroups, gave updates. Since that point in time, 1 representative from each subgroup has met in a conference of subgroups to discuss the overlap between their documents and recommendations. In addition, the mixture interpretation subgroup has met. The human factors subgroup had to cancel a meeting, but they will be meeting over the next few weeks to continue discussions. Both groups anticipate at their August meeting having the work finished to provide to you all in September. Anything else there? Okay. We amended the agenda to include new business item. Jessica, do you want to give the background as it was your addition, the Qiagen?
Sure. I think I gave what I know at the beginning. Maybe somebody else has additional information. But Qiagen, who supplies forensic DNA labs with equipment and reagents, had received complaints from a number of customers saying that they use the Easy 1, Easy 2 extraction kit. And we're getting unintuitive results, lower than expected DNA yields. I think they discussed this at the Texas Forensic Commission meeting in April of this year, which is publicly available. But I think it was the Houston Center said, you know, they do this blind quality testing, and they were sending out blood samples, but getting no or very low amounts of DNA back, which was not expected. And apparently other labs had issues, reported this to Qiagen, and Qiagen has sent a letter to its customers informing them of this. It listed a series of lot numbers that were affected and did say that it had done some sort of internal investigation to see if it affected other products. It's not quite clear what that is. But I think we're interested, right, as a commission, knowing whether the labs in New York State are affected, whether Caseworks affected, and how labs are going about trying to figure that out.
So they do have a follow-up too, so there's a second follow-up. If you go to the Qiagen website, I can send them to you.
Yeah, great. Maybe we can include those for the September, if you send it to
I'll send them
Shelley.
to
So I think we had discussed when I moved to amend the agenda, there were a couple of suggestions by DA Fitzpatrick and Michelle Schmitz of Erie to have BioTwig take a look at this and then report to the commission in September. Is that right?
Yeah, I feel that would be appropriate. The BioTwig are subject matter experts. And so the process would be for them to put something together and go through NICLAC to provide it to the commission. So that way the lab directors have eyes on their recommendation before it comes to this level.
Point of clarification, I think I also heard mention of the subcommittee. So is the request to have it to the subcommittee in August and the commission in September from the BioTwig?
We could do that if that's what the commission would.
Somebody had mentioned something.
I had mentioned that. I think it would be helpful to make sure that they're looped in on the analysis. I think it'd be useful to know which, I think you had mentioned this previously, but which labs use this kit, you know, what, if anything, they have done, or, you know, whether they're alerted. I understand that, I mean, 1 million notices come in from these companies, and making sure everyone's aware this one's quite serious.
And if their kit QC procedures are sufficient to detect it.
Mm-hmm.
One question, what are we asking the BioTwig exactly?
I think it would be best for them to have the discussion what labs are affected, you know, who uses this.
Who's using the investigator kit or not.
Yes.
Okay, and rather than distribute it to the lab
labs,
directors and have you guys trickle it down to your.
Reminders, sorry.
I'm sorry. Right. I think rather than it comes through the lab directors to find out who is, I think it's best for the BioTwig to have that discussion, gather that information, who's using the kits, and if so, how they're affected, and then funnel back up through NICLAC.
I think and I might be wrong, but it really is up to BioTwig. I think it's. I think the situation might be an MTL like 1 or 2, but there's 2 different types of buffers that can be used by the laboratory, and I think it may have been one of them, but it even had to do with cassettes too, so better off coming from them. So I won't forward this info. I'll leave it for them to do the Qiagen letters, because they have.
So the motion is to send a letter? Is that who's making the motion to send a letter to BioTwig? Or send a request to BioTwig?
I'll move to send a letter, a request to BioTwig, as well as to the DNA subcommittee to review all the publicly available and privately issued disclosures related to the Qiagen issue, to assess through conversations with lab directors which labs in New York may be affected, as well as their understanding of the issue and the state of any reviews, and to maybe this is beyond the authority, but work with those labs to help them understand what may need to be done, or communication share across labs if issues are identified, et cetera. And then to report to the commission what they've learned and what steps are being taken.
Is there a second?
Yes.
Thank you. So the second was Jessica. All in favor, please say aye.
Aye.
Anyone opposed? Any abstentions? Okay. That brings us to laboratory disclosures. Erie County Medical Examiner Office of Forensic Toxicology Laboratory. The laboratories provided a closeout memo to DCJS and ANAB for unexpected results on a proficiency test first discussed at the March meeting. Pentobarbital and bromazepam were not reported, and following the investigation, it was determined the internal standard recovery was low, and the sample was not reanalyzed through laboratory policy though laboratory policy recommends it. Consultation with the chief toxicologist or toxicologist 3 was implemented to determine appropriateness of reanalysis for samples with low internal standard recovery. 3 months of data was reviewed by the laboratory director, and following the corrective action and all policies and procedures were followed appropriately. Are there any questions regarding this?
Yes.
Okay. I believe we have the laboratory director available virtually. If you could please join us. There we go. Can we hear you, Melissa? Could you test your
Good morning.
Thank you.
Hi, Melissa. It's Lydia DeCastro.
Hi.
Hi. I'm looking at your email dated May 13, follow-up of CAR 250001.
Okay.
First question about cutoff calibrators. Is that considered the lowest and the highest? What is exactly a cutoff calibrator?
A cutoff calibrator determines whether we call something positive or not. So if it's above the cutoff calibrator, we'll call it positive. If it's below, it's not reported.
Semi-quantitative.
Okay. Is there only just one cutoff calibrator?
Yes, these are just screening methods.
Okay. And then a little further down, you refer to a toxicology lab links manual testing. What is that referring to?
It's just one of our SOPs. This SOP is a general SOP that applies to all the methods in the laboratory.
Oh, okay. So you described what the policy and procedure was, and that's the name of it.
Correct.
Okay. And then in looking at point number 5 for qualitative LC-MS-MS assays and LC-QTOF, internal standard abundances should be within negative 50% to positive 200% of the average of the two calibrators. Is that wide range due to a qualitative versus a quantitative analysis? It seems like a wide range to me. 50% to 200%, or is that the standard or the norm?
I believe that's the norm. That's how it's always been since I started. I believe it was part of ABFT recommendations when we were ABFT accredited, and we just continued that.
Okay.
Right.
I had a couple more.
Okay.
I think it's on the next page. It is noted that even upon reanalysis, there is not a guarantee that pentobarbital or bromazepam would be detected. So does that mean that there's, maybe generally is too strong a word, but it's enough of a problem that you have to make a note that there's no guarantee that they wouldn't be detected?
We would only make a note on the final report if there were issues with the internal standard. If there aren't internal, or not sure. Do you have anything for that? I think that the main issue is that it's a urine sample. So those tend to extract differently than blood samples. And this is a known phenomenon, so.
Okay, I got it. You do say
Yeah.
that previously about urine. All right, I
Yeah.
understand.
Yes.
That's all I have. Thank you.
Okay.
Any other questions for lab director? Thank you very much.
No problem.
Next, we have the Monroe County Crime Laboratory. The laboratory has made an initial notification to ANAB and DCJS regarding an incorrect name that was provided to another lab in response to an ENDIS hit. The corrected information exchange form was provided and the incorrect name was not released by the other laboratory. The lab is investigating the issue and has revised their notification form and put an additional check in place. Are there any questions for the laboratory? Yep, sure. We have the lab director, quality manager available.
Good
Hi, can you
morning.
hear us?
Yes, I can hear you. Can you hear me?
We can. Good morning. This is Erin Murphy. I was just wondering how the incorrect name was produced. Like where did it come from?
It came from a second set of cases that hit to one another. At the time of this incident, we were working on two different groups of cases around the same time, and the name came from that second group of cases.
And so it was like the same analyst is working on multiple cases and they just kind of got mixed up about which case to case hit went with which?
Just got mixed up with the name.
The name. Because there were like multiple, because the names aren't in CODIS, right? So like the multiple files are on the desk kind of situation.
Yes, that's correct.
And then I'm wondering how it was caught, just because it seems like it would be easy to not get caught.
It got caught when we were reviewing the CODIS letter or CODIS notification letter.
Maybe I don't understand what's entailed in that review that would like how you would recognize like, oh, this name is not associated with this properly.
You go over that?
Yeah.
Maybe you could answer.
So this is Mara Somer. I'm one of the forensic biology supervisors. The name was received from a direct reference sample. The CODIS information exchange letter between our laboratory and another laboratory was where the incorrect name was shared. When we were writing the notification letter to our customer, that letter gets reviewed as well, and the reviewer of the notification letter caught the discrepancy between the CODIS hit name and the reported case name.
Okay, no other questions.
Anyone else? Thank you.
Thank you.
Nassau County Office of the Medical Examiner, Division of Forensic Toxicology. The laboratory has notified DCJS and ANAB of an unexpected ethanol proficiency test result in which the analyst result was outside of the PT's acceptance criteria for one sample. This proficiency test was part of the analyst training and they had not performed casework, therefore no case results were affected. The analyst completed additional training and was authorized to perform casework. There's a second notification regarding an unexpected acetone proficiency test result. Acetone was correctly identified. However, quantitative testing results were outside of the laboratory's acceptance criteria. The laboratory is investigating and found that no vitreous acetone testing has been performed in casework over the last 5 years, and quantitative reporting of acetone in vitreous specimens has been suspended. Are there any questions regarding either of these incidents for the lab?
Yes.
Okay. I believe we have the assistant director available.
Hello, can you hear me?
Yes. Good
Okay.
morning.
Good morning.
This is Jessica Goldthwait. I just had a question with respect to the acetone failed PT. You noted in your investigation that the calibrator solution was out of date, or it was expired. And I just wondered, what procedures do you have to prevent the use of expired solutions, working solutions?
Well, the procedure was exactly followed. It was noted that it was expired. It's a sealed vial that we use for calibrators, and once it's opened, it's good for 7 days after that fact. It was noted at that point that it was past 7 days, and we had procurement issues where we could not purchase a new lot in time. So our procedure is at that point, though, we cannot do quantitative testing. We could do qualitative testing, which was done.
Was it part of your, I guess, validation work that you, I guess, in the course of validation, tested expired solutions or solutions that have been open for longer than the 7 days, and they did work, or
Correct.
why are you using expired solutions?
Yes, correct. As part of the validation, we do stability studies that looks exactly at that in terms of what is the appropriate period of once that sealed ampule is opened, that we transfer to another storage container, and at what point is the reliability in terms of quantitative testing, no longer valid at that point. So that was part of our validation packet.
And that's some point longer than the 7 days?
The 7 days is what we set as the furthest period that vial could be used past its opening date. So anything after 7 days, we would just use for qualitative purposes, not quantitative.
Okay, thank you.
You're welcome.
I'm just curious, this is Erin Murphy, what caused the procurement delay? Was it an internal issue or an external issue?
That's external to the county.
Counties get their...
County's very slow in processing requisitions and purchases.
Disappointing to hear. I hope the county understands the importance of having a solution.
They are working on upgrading their system currently as we speak to hopefully make it more efficient.
Thank you.
Any other questions for the lab? Thank you.
Thank you.
The New York City Office of Chief Medical Examiner, Department of Forensic Biology is next, and we have two issues here. The laboratory provided DCJS and ANAB with 2 interim updates regarding the case-to-case contamination investigation, first discussed at the September 2024 meeting. Retrospective review of cases examined by the criminalists involved is in progress. Also, since late 2024, the laboratory has provided a QC monitoring process based on customer request. A 2021 case that was processed on request resulted in the identification of another contamination event, and the lab is continuing their review. Additionally, the laboratory has provided a closeout document for 3 unexpected proficiency test results. The first PT closeout is regarding an unexpected blood screen result first discussed at the September 2024 meeting. Analysts have successfully completed a competency test in the lab, examined past cases with no additional cases found to be affected. Second closeout is regarding an inconclusive PSA result that was first discussed in December 2024. The analyst completed a competency test and has not performed any casework yet, therefore no cases were affected. And the final closeout was related to an inconclusive semen result first discussed at the March 2025 meeting. The cause could not be determined, and retesting results were negative for semen, which was consistent with the expected result. Are there any questions regarding any of these issues for the laboratory?
Yes.
There are members of the lab here today. I'll invite you to the table and remind you about the mics. Additionally, there are a few people virtual that might want to join from OCME. Okay, go ahead.
Morning.
All right, just a question about the retrospective. So I didn't understand what, just this one sentence. The following retrospective is in progress. All cases examined by the 9 criminalists who had more than 2 contamination events, and then in parentheses, 4 of the 9 criminalists. So is it 9 criminalists or 4 criminalists who had more than 2 contamination events? Or I just wasn't understanding what that meant.
There are 4 criminalists who had more than 2 cases that had contamination.
Out of those 9?
Out of the 9, yes.
Okay, okay. So it's only 4, it's not 9. Okay. Hang on one sec. Oh. Moving to the molecular serology testing, this is in the additional documents. The following steps were taken to address this matter. Well, it's not about the steps so much. Is the molecular serology test done on individual samples or are they batched? I don't know how it works. Because I was wondering, because it says both cuttings yielded a detected result for saliva and a not detected result for semen. So after the cuttings are made, are they batched and put on an instrument just like a lot of the other things that we do as far as the case throughput?
Yes.
Okay. Because I was wondering whether were there other samples that were tested on the same day using within that batch, or was it just this particular case, the PT? I'm wondering whether there might have been something cross-contaminating that would cause that positive and
Right,
negative.
that we don't know first. I don't have firsthand knowledge of that. We'd have to look at the specific case, but I would imagine that there was some batching that was done. We tend not to do proficiencies by themselves because we want to treat them like casework as, the intent of the proficiency test. So that is one plausible explanation, but as the letter says, we are unable to determine exactly what took place.
That's all I have.
Yeah, and then
It's quick. So it was more so of concern of the specificity, right? You're getting a sample that's PSA negative, right? Which I don't know if you still do immunodiffusion, probably not at this point.
No.
The question is, what would you have gotten on it? But is there a concern that on a sample that should have had no specificity to whatever, KLK3, statin, whether you're looking for semen, saliva, or whatever else, is there any concern about the specificity of the assay?
No, at this point, based on the way the validation was conducted, and I believe our technical leader, molecular serology, is on the line, but they did look at the entire proteome of every living thing on the planet, as he says, and was able to create the assay with enough markers that it is specific for semen.
Okay, it's just getting 7, it's a little concerning to get that many markers.
But,
They want to go back to blast.
but even with that many markers, it was still considered an inconclusive
Right.
result because for conservative.
Okay, it's just,
Oh, Pat, your microphone.
oh, well, that could do it. I'm at the end of my, discussion, but sorry. I was, again, my concern was the specificity of the assay rather than the potential of a cross-contaminant. That's just, as long as, the question was, that's being investigated.
Yeah, it was looked at, and like we said, that's part of the possible explanations. We just aren't unable to pinpoint that at this point.
Okay.
Can I just follow up on that specific point? Because I had the same question, which is if it is meant to be a negative, there's a big difference between negative and inconclusive. So, and I'm not sure I'm following the technical aspects of the discussion. So the idea is your view is your test is so comprehensive, it picked up accurate signals that the testing kit company does not consider within the range of inconclusive as opposed to negative?
Well, the testing company prepares the samples, so they prepared the sample and they say that it's just saliva. So they're not considering, the testing methods that the labs are going to be using. But yes, so the testing company was expecting, whatever test you use, it should just be positive for saliva. And our result was positive, detected for saliva, but inconclusive for semen, because 5 peptides had been detected.
That's what I'm trying to understand is like, because these are manufactured tests, so presumably there's a ground truth that's known, like they spit in a vial or, and if the ground truth of the testing company is there is no semen in this sample, it's only saliva, therefore it should return a negative for semen. I'm trying to understand a test that can return an inconclusive with a known ground truth of negative, and whether the answer is, there was in fact traces enough of semen in there that, they're unaware of. And if so, that seems like a conversation to have with the testing company.
Right.
Or whether there's something about the specificity of this instrument that's returning a result that even the testing company says is not possible on ground truth.
Or it could have been some trace amount of cross-contamination that happened within the laboratory.
Or, well, right.
Those are the three major things that we were thinking as well, and we are unable to make that determination of which one of those 3 it was. But I believe we did have a conversation with the manufacturer.
We did not have a conversation with the manufacturer, but when you're given the test report from the vendor, it does show you anonymously all the results from different laboratories, and there were 2 laboratories that had positive results for semen, but it was with Ceratec, with a different type of test.
Okay.
We kind of knew with any kind of retesting in this situation, we wouldn't be able to determine what happened. But we did try. We retested the sample right next to the cutting. We cut it again right next to where they cut and a little bit further away. So just in case it was something with the preparation of the sample, maybe they did have a little bit of semen on this circle, but not on the right side, the outside of the circle. So that's why we took the 2 cuttings, but they both were not detected at all. No peptides for semen, but again, positive for saliva. So again, it didn't lead us to conclude whether this was the vendor, it was contamination in the lab. That's where we are.
And it's fair to say that the molecular serology technique being used is much more sensitive than Ceratec cards, right?
Correct.
Clarity.
Yeah, Ceratec is considered a presumptive test.
Yep.
May
Yep, go ahead.
So I'm just referring to your March 28th letter to the community where you were discussing the review of the case-to-case contaminants. And am I correct that there was a certain period that you decided to go back and examine and look at samples, and in addition, you offered quality control monitoring to customers on a requested basis. And in one of those instances, so it falls outside of your review, and in one of those instances that fell outside of your review, you found a cross-contamination problem. Is that correct?
That's correct.
Okay, so 2 questions. One is, did that cause you to re-examine what you're looking at, number 1?
Yes.
And 2, has there been any consideration on working with the prosecutors' offices to identify cases that are going to trial so that those can also be quality control monitored before trial commences?
So anyone can request before.
I got that.
So they're all aware that and we do get many requests for cases that are going to court for QC monitoring.
Prosecutors as well as.
But it's just not a standard operating procedure that they notify you, and you do that considering where we are right now. It just seems like something's fallen out of the period that you're examining.
Correct.
And that kind of changes the scope of what we're looking at potentially.
Yes, and there could be reasons that they have that's independent of us for not asking for that. So that's why we didn't want to put it in as a standard process to just do it on everything, because they maybe not need the DNA, for instance. So we left it up to them to make that decision and offered it to both the prosecution and defense. Obviously, the case that popped up in 2021, we are now gathering and rethinking the strategy as to look back and also for future monitoring. So that is still in progress. We're still processing that and still
Kind of like
discussing.
a mini root cause analysis of what happened here.
Correct.
Okay.
In that mini root cause analysis, are you looking at that particular analyst, all their casework?
Not all of their casework. That's still being discussed as to what we will do in terms of that particular analyst and that particular time frame. So we didn't want to just jump in to start, again, blindly. Not that we were doing it blindly, but just start looking at everything without a game plan as to what would be the appropriate next steps forward.
My understanding is that analyst wasn't a new analyst, so wasn't part of the same training class that the other 9 analysts that had been detected as doing case-to-case contamination were a part of. Is that right? When did this analyst start at OCM?
At the time in 2001, that analyst was a criminalist. Sorry, in 2021.
Wow.
Not that long ago. These people.
Criminalist level 2, I believe they began in 2018.
That's what I was going to say.
Around 2018, so they wouldn't have been doing evidence exam routinely at that point. So, and just to clear up, the 9 previous ones weren't all a part of the exact same training class, but they were around the same time that they came.
So it sounds like you're devising a sampling plan, which leads into one of my other questions, which is right before the last meeting, obviously you had received 2 letters from statisticians, Dr. Alicia Karakuri and Dr. Dan Rabinowitz, who both talked about sampling plans and their importance. I do see in these most recent disclosures, you are using the same type of reporting that both statisticians said didn't give you the full picture of what's going on in the lab. Specifically, Dr. Karakuri said you're using the wrong sort of denominator by saying we reviewed, 12,000 cases or whatever, may not be the proper denominator. But so I'm interested in what your reaction is to those suggestions, and specifically, what is is it going to affect your sampling plan for quality monitoring going forward? And also this sort of mini investigation to this 2021, it sounds like you are considering how to sample this analyst's cases and how to deal with this. So could you describe that, those 2 things, I guess?
That was a multi-part question.
It was.
Well, with the letters themselves, we're just stating the facts. We're not trying to imply any sorts of contamination rate. So, in terms of the number of cases that are affected and samples versus number that looked at, I know it might be easy just to put those 2 numbers together and come up with a rate, but we're not trying to imply that rate at all. We're just saying this is what we've done so far. We have certainly looked at the 2 letters that we received, and that is part of our discussions about moving forward is like, what is the appropriate number of cases, samples, analysts, timeframes to be looking at. It's not trivial. I believe in Dr. Rabinowitz's letter, he even mentioned come up with a novel way of looking at this, which obviously is not going to happen overnight. So we are in discussion amongst ourselves internally, and we've also reached out to some external possible vendors to look at helping out with this, answering this question as to what's the appropriate denominator. Can we calculate some sorts of contamination rate if that's something that should be done at this point, and what is the appropriate number of not only samples to look backwards on, but then going forward in terms of monitoring. So we do want to add that to the discussion in terms of adding that biostatistical aspect to the investigation.
That's good to hear. In Dr. Karakuri's letter, she did suggest, and maybe this is part of your discussions with the vendors, but she specifically listed some data points that would be helpful for stakeholders to understand this case-to-case contamination. Have you given any consideration to making this public?
It's part of the conversation. So that is, like I said, we've digested both letters and are obviously taking their suggestions to heart and including that in our conversation.
When will you make a decision on how you're going to move forward?
I can't give you a time frame on that just because, you know, there are certainly a lot of factors that are going into the look back itself and conversations that are being had with different individuals. So I would hesitate to offer up any sorts of time frame right now, unfortunately.
Yeah. To dovetail on Lydia's questions about the 4 analysts of the original 9 that had more than 2 or more instances of case-to-case contamination, how many of those 4 had more than 2? I know at least 1 did, but
All of the 4 had more than 2. That's why they were chosen. It was how many of the 9 had more than 2.
and what are the specific numbers for those 4 individuals?
Have the exact specifics.
I mean, are they contaminated? In your initial disclosure, I think when this first in September, at least one analyst, right, had 5 instances. The first analyst that was detected, maybe 4 or 5.
Yeah, there a couple of analysts have, you know, they all have different numbers. We don't have those handy right now in terms of who has what number.
Do you know what the most number of case-to-case contamination incidents are? Is it more than 5?
For one individual?
Yeah.
Is that what you're asking?
Yes. Mm-hmm.
Yes.
5, yeah.
Yes.
Do you know what the number is?
I don't know the number.
I don't know the number.
In your March letter, you had said, so for those 4 individuals, you're reviewing all of their casework. Is that right?
Yes.
Okay. For the 5, I think your March letter indicated that you would be looking at a subset of those remaining 5 analysts, but I didn't see that in the updated May. But is that still the case that you're going to be or have concluded reviewing a subset of the casework for those 5 of the 9 analysts?
Yes, that's still ongoing. Obviously, we started with the 4 that had more than 2. So many numbers thrown around.
Yeah, I know.
But that doesn't mean that that's just what we're doing. That's just this current phase of the investigation. Like I said, we're discussing what the next phase will be.
So does that include how you're going to sample the subset of those 5? Have you made that decision yet?
We have not made that final decision as of yet.
Okay. Have you detected any additional instances of case-to-case contamination since your disclosures that you made?
Well, since May,
Since
yes.
May, it's
Yes.
my apologies, yes.
And what is the final total?
Currently, it's 45 contaminated samples that had been contaminated and 40 that encompass 40 cases.
We're actually in the process of doing another update.
Yeah.
We just did not get it done in time for this meeting. It'll probably go out this afternoon, actually.
Oh, okay. So 45 samples from 40 cases?
Yes.
What is the oldest sample of case-to-case contamination?
Well, the 2021 case.
Oh,
but,
yeah.
But of the newer ones added, it was, I believe it was from November 2022.
November of 2022. So you've already started sampling the older, or did that come up as an instance of quality control request by a
No, that was
stakeholder?
part of the cases examined by the 4 analysts.
Ah, okay, I see. And does any of the additional samples that you've detected, do they follow the same pattern that you've described where you have a high template from blood, sex assault, contaminating a lower template?
Yes.
Okay. Any variation from that pattern? Okay. And you said the notification today or Monday?
Yeah.
Sorry, just one final thing. We talk about 21. Now there's something in 2022. In 2019, that was before, obviously, I was on the commission, but it made the news, right? There was this instance where an analyst examined a sex assault case, went to lunch, came back, and then examined a property crimes case and contaminated the property crimes case with the suspect from the sex crimes case. And the wrong person was arrested and prosecuted for a while before this was investigated by the DA's office and your agency, and the charges were dismissed. In the root cause analysis significant event disclosure, there was a recommendation, right? It seems like what happened, and correct me if I'm wrong, but the analyst either forgot or there was improper cleaning procedures of the scissors that had been used to sample the Sexasol swab or exemplar, and then the property crimes evidence case, I guess exemplar to then evidence. One of the recommendations of the root cause analysis committee was to re-examine your cleaning procedures, and this was back, I guess, in 2019. Did you do that back in 2019?
It was discussed amongst the management team, but it appeared, for all intents and purposes, that this was a one-off even for that particular analyst. We did look at all of their past work as well. So it was determined at the time that our cleaning techniques were sufficient for the work that you're performing.
Can I quick follow-up to that? Your letter, May 8th, says that one of the safeguards that were employed was a standardized cleaning protocol was implemented. Does that infer that there wasn't part of your standard operating procedures a standardized cleaning protocol? So analysts would.
I wouldn't necessarily say it wasn't standardized. I think it wasn't as specific in terms of how analysts would be interpreting that procedure. So there was a procedure, there was a standardized procedure, but we needed to add a bit more specificity on the specific ways of going about the cleaning, and that's what we did.
Then if the standardized procedure of cleaning could be a possible root cause of what happened, doesn't that suggest we have to go back to, I don't know how far back, but if there's no standardized cleaning procedure before it, and now the standardized cleaning procedure is hoped to resolve it, doesn't that open up the window of time that potentially we'd have to look back?
We're still evaluating everything, but again, even with that particular analyst, there was no indication back in 2019 that there were any other instances of issues with their cleaning of any tools, their evidence examination. So
it's not the cleaning procedure necessarily per se, but the way that procedure was utilized.
it may very well have just been that the person on that day had not realized that they had gone off to lunch. Maybe they were distracted as they were going off to lunch. They didn't realize that they hadn't cleaned the tool. But in every other instance, on every other day, for every other case, they clean their tools. So it doesn't necessarily indicate that there was something wrong with the cleaning procedure or the person was not cleaning anything properly. So again, we're still evaluating everything as far back as we can, as is relevant to what's going on. We want to make sure that everything that's been reported out is correct.
Is that something that's shared amongst all the labs? Is there a standardized cleaning procedure at most labs?
Sterile techniques, I mean,
So no one specific procedure?
Not across the labs.
Not across the labs.
Each lab would have their own procedure
That's what I'm
separately.
saying, do labs have as part of the standard operating procedures, a standardized cleaning procedure?
I can't speak for
the
the
all
all
labs,
labs.
I know we have them. We have them in our training procedures also, so we pretty much have them everywhere.
Again, it would also depend how specific that procedure is. Like, does it say clean your tools with bleach followed by water followed by ethanol, as opposed to 10 seconds here, 60 seconds here, 5 minutes here. So that was one of the things that we currently looked into and updated the procedure. So there was a standardized procedure. We just added to it to make it more specific.
Because one thing is that, and I don't mean to sound like I'm 100, but in today's generation, if it's not written, they're not doing it. It's not there, I'm not doing it. So for this generation, it has to be in black and white. And I'm seeing it at a collegiate level also.
Noted.
Can I ask too, I don't know if NICLAC or the BioTwig has talked about it, but just to make sure other labs, I'm sure they are, I hope they are aware that they should be looking at their sterile techniques and their cleaning techniques. I don't know if it's been discussed in any of those forums.
In BioTwig, I can speak for that. We have had discussions about it. Obviously, we've told them about the situation.
Yeah, that's great.
And,
I mean, to make sure they're aware.
Some of the blind spots, so to speak, in the quality that they should be aware of, and that was certainly being discussed. I'm not sure if NICLAC has taken up either, but I know at the BioTwig we've discussed it.
We got QA Twig next week, so I'm sure this will be something that we discuss.
Right.
I was just gonna say, I think that's a great point and important, especially as these tests become so sensitive and maybe people who've been around for a while and aren't accustomed to, how, like thinking of it in those terms, might need to revisit protocols that worked 10 years ago.
And with all due respect, I think that's the important value we have in the QA twig and the
Yeah.
bio twig is it allows the experts to have that conversation because maybe you think, you know, your SOP is detailed enough, not understanding like, wow, maybe people are making assumptions or drifting a little bit,
Yeah.
you know, just because it's not in writing or they think, you know, that's common sense.
Yeah.
Maybe it isn't
Yes.
common sense to everybody. So from the NICLAC perspective, we really rely on the QA twig and the technical twigs to have those discussions and keep each other kind of abreast of situations that have come up in issues. And hey, it doesn't hurt to take a look at your own policy and make sure it doesn't need a tune-up.
Yeah, and I think the lesson learned about the specificity for generational reasons and the specificity for common sense versus like 10 minutes or whatever.
Yeah.
Important.
Any comment or discussion in Albany?
Can I ask one more quick question? Is the QC form that you're using, that doesn't have a time bound or analyst limit on it, right? The thing that prosecutors or defense attorneys can submit for review, it just is, you can just submit any case. It's not like you can only go to 2021 or whatever.
The time bound would be for cases since we've used Fusion and StarMix. So the earliest we could do is 2017. And then up until we made the changes in all of our cleaning protocols to August 2024. So those would be the sort of
That's
front and
that.
back end of
But
the
it's
batch.
not, it doesn't have to be one of these identified analysts, or I
No.
assume from the, okay. Thank you.
Thank you.
Thank you.
Okay. Up next, New York State Police Crime Laboratory. 2 items here. The laboratory notified DCJS and ANAB of a closeout of incorrect reporting of serology results, first discussed in the March meeting. Results obtained for blood screening on 2 items by a DNA analyst were conflicting with results reported by a separate serologist in November of 2024. Revisions to the screening protocol and documentation requirements were made and discussed with serologists. A review of all serology reports completed in 2024 with similar screening results was completed with no other issues identified. The serologist was issued 2 competency tests and data entry was monitored. The laboratory considers this event closed. Second item, DCJS and ANAB were also notified of the closeout of an unexpected result on C's drug proficiency test discussed in the March 2024 and June 2024 meetings. The analyst's work in cocaine quantitative and cannabis methods was stopped in December of 2023. Several factors, including the lack of anti-static device on the balance and the analyst's technique, were found to have contributed to the issue. In response, test methods were revised to require the use of anti-static device, and the analyst was retrained on various aspects of the process. The analyst successfully completed a competency test and has been reauthorized to perform casework in these methods. Any questions for the laboratory regarding either of these topics? Okay, hearing none. Niagara County Sheriff's Office Forensic Laboratory. Laboratory notified DCJS and ANAB of an unexpected result on a toxicology proficiency test. 2 metabolites of cocaine, EEE and EME, were expected results. The laboratory routinely confirms the presence of EME, but does not screen or report EEE. Following the investigation, the laboratory did identify the correct analyte, but due to a transcription error, reported the incorrect result to the PC provider. Since the lab does not screen for or report EEE, and EEE cannot be selected in limbs, there is very low likelihood that this would happen in casework. Casework from the past year was reviewed to ensure EEE had not been reported. No cases were found to be affected. Are there any questions for the laboratory?
Can I just say for both of these that, you know, I appreciate the thoroughness of the lab's responses.
Suffolk County Medical Examiner Toxicology Laboratory. We have 2 things here. The laboratory has notified DCJS and ANAB of a report that contained a compound identified in initial screening results, but not confirmed. The laboratory issued an amended report and reviewed all reports signed out on the same day, with no additional issues being found. An updated results sheet has been created and the staff has been directed to verify results are confirmed prior to reporting. The laboratory considers this event closed. DCJS and ANAB were also notified of an unexpected result of an ethanol proficiency test. The laboratory is investigating the issue and believes the cause is related to improper pipetting technique. The analyst is in their training period and does not perform casework. Are there any questions for the laboratory regarding either of these?
Yes.
Okay, thank you. We have the lab director and quality manager available virtually. Good morning.
Good morning. Can you see us?
Yes, and we can hear you.
Okay.
Good morning.
Good morning.
I had a question, not about the, what was that acetone? Not about the failed PT acetone, but the, I'm not going to be able to pronounce it, but desmethyl-venlaxif, you know what I mean?
Venlafaxine. Yeah.
The ODB.
Just don't take it.
Just don't take it. So I just want to clarify, you did review cases. Initially, it seemed like you said you only reviewed cases to ensure that this issue didn't happen in any of their samples on that one day. But then I think later on in our materials, you said you looked at an additional 30 cases signed out from February 7th to April 30th. So I just wanted to make sure I knew the scope of your review of casework to make sure that it wasn't affected.
Yeah, originally we were just going to look at the ones from that day, but there was only, I think, 10 or 12 cases, and I wanted to expand a little further. So I decided to go 2 months back just to ensure that cases that were reported by this individual and reviewed by the individual were looked at together.
Right, because it wouldn't seem to make sense just to look at that one day, right? The problem could have, okay. So was the 30 cases all of the analyst cases or just a sampling of them? And if so, how did you do the sampling?
It was a sampling of them. It wasn't all of them. It was just whatever ones I could come across in that 30-day period that 230 days, 6-day period that had cases involving both individuals.
The original analyst and then the reviewer, or?
Correct. Yes.
Okay. And this, just to understand the issue, this was, you did a presumptive test that was positive when it shouldn't have been. So a false positive, but only on a presumptive test, is that right? That was mistakenly reported as confirmatory?
Yeah, the confirmatory test didn't pass, so we wouldn't report it unless both tests passed. And in this case, that value was entered on our result sheet in an area usually recommended for result in confirmatory tests. And that's where the confusion came into play, which is why we updated the result sheet to separate the two of those so there could be no further issues.
Did you do additional confirmatory or another presumptive test just to see how it would come out?
No, we didn't.
Okay, thank you.
You're welcome.
So if I, oh, go ahead.
No, please, if it's about this.
It's the same, yeah.
Yep.
I just want to make sure I'm understanding correctly. So I think I had initially, when I read the materials, I thought that what happened was the analyst wasn't aware they needed to do the secondary confirmatory. But now, from what you're describing, it sounds like they kind of filled in the form because of the way the form was structured at the time with the presumptive result, which was this positive. And then they did do the secondary and it was negative, but it didn't go on the form somewhere?
Correct. Yeah, so the initial test should have been in the screening section of the form, and the confirmatory result, being that it was negative, would have been in the secondary. So it got crossed up.
So it was written in the secondary and then the analyst just didn't put it anywhere, didn't put the negative anywhere on the form or put it in a different wrong place?
It was on the form, but there was 2 spots.
Ah,
So sometimes you do multiple testing, so it's possible that a repeat analysis could be positive even though the original was negative. So in this case, it's possible that's where the confusion was for the reviewer.
And so is your understanding of what was happening with the analysts is just that they were filling in this form? What is your understanding of like why this happened with this analyst?
In this case, seems to be a one-off. They usually put it in the right spot. I don't know why they happened to put it in this area this one time.
Okay. Thank you.
Yeah.
I have a question about the, excuse me, the second incident. This is Mike Marciano. So this person, this analyst, at what point are they in their 2-year training program?
At this point, they're at the end of it.
Okay. And are they signed off on any other types of analysis at this point?
Yes, they are.
Has any of their work been looked at? Because pipetting is a pretty important skill to have.
Yes, we have looked at her other testing and her other competencies and PTs, which have all been passed.
Okay. Thank you.
You're welcome.
Any additional questions? Comments? Albany? Thank you. Up next, Westchester County Department of Labs and Research, Division of Forensic Science. Two situations. DCJS and ANAB have been notified that the difference between trace section analysts and interpretations regarding hair suitability for nuclear DNA analysis. During the investigation, it was found that the hair examination procedure was not specific and did not provide clear guidance in determining suitability, and case records did not provide sufficient documentation for technical reviewers to determine that the conclusions were supported. Procedures were updated, cases were reanalyzed, and amended reports were issued. DCJS and ANAB were also notified of an unexpected result on a trace proficiency test. While the PT provider has not released the results yet, the PT did not make it through technical review in the laboratory and therefore was deemed unsuccessful based on the laboratory's quality manual. Are there any questions regarding these two topics?
Yes.
Okay. Today, Lydia will be representing the laboratory.
A couple things. First, I think I've made this comment before, but it was nice to see a laboratory disclosure about this issue directly to the defense community. I noticed that you did send a letter informing legal aid of Westchester that this analyst was mistaken in concluding that quite a number of hairs were not suitable for DNA testing when in fact they were. So I would hope that other labs in New York would follow Westchester's lead in informing the defense directly in an issue like this. I did know, in addition to your including the letter to legal aid in Westchester, you also included a separate disclosure. Obviously, most of your customers are in Westchester. This one happened to be a New York City case from the Bronx with ADA, I believe, Myris. And I believe it was a homicide. The individual was acquitted of the homicide, but convicted of a misdemeanor offense and was sentenced. It wasn't clear just from the one communication whether your laboratory had reached out or even knew who the defense attorney was in that case, or whether ADA Myers had made that Brady disclosure to the defense.
I'm not aware of that having happened.
Okay. Okay. Because it is clearly sort of an apropos of our earlier conversation, it is Brady. You have made the disclosure, but I can contact ADA Myris and see. Another thing I wanted to ask about with the hair examination was you did helpfully include a selection or a portion of the protocols for hair identification. I did see, almost incidentally, since it wasn't the subject of this nonconformity, but I did see that there is ancestry determination in the hair section, and that is, it's not reliable. It's highly controversial. So I just wanted to ask if your laboratory has any plans to re-examine your use of ancestry determination through hair examination.
We are not doing that type of analysis. And when I was presented with this packet from our quality manager and saw that this was in the manual, I also questioned it and was concerned that this was actually still present as a possibility, because I myself would 100% agree that this is not something that we should be even considering doing anymore. And I was alarmed. So I inquired, and no, we're not doing this. And even if they were thinking about doing it, we will not be doing it. And as a result of this particular incident, this manual is being rewritten, and this will be removed in due course.
Thank you.
Yes.
One thing, just for a suggestion, is to this day, we still get a second eye. Like, we'll take a stereo digital image of it, of the bulb material, and then we get someone else to come in before they make that determination as to
Well,
suitable.
I think we noted in the report that upon technical review, there was not a photo for the technical reviewer to concur or disagree with what the analyst had. So that has been added to the manual as part of the protocol now.
Especially on like synthetic hair. I mean, sometimes you'll get something that looks like hair. It's just not even hair. So.
Yeah, so I mean, this is one of those things where you discover areas for improvement only after there's a problem. So, but I'm grateful to have an opportunity to improve, even if it's discovered in this fashion.
It's a good improvement too.
I have two quick questions.
Sure.
One is, I think there was one case where the hair was no longer available.
Yes.
But the attorneys were notified about that case as well. I just wanted to.
I believe so.
Make sure.
Let me just read what I reported. Do you have a page where we?
I was just trying to find it.
I
I wrote
know.
185, but I don't think it
Okay.
is 185. I don't know.
I think I read that too.
It's in the.
I guess, I mean, the answer is less important than just, I think they should be,
Sure.
that they should be aware as well if they weren't. And the other question was just if DNA analysis has been attempted on any of the 22 that were found suitable.
Say again?
If a further analysis was attempted on any of the 22 hairs that were found suitable.
So we've been in touch with the conviction review unit with the Westchester County DA's office, and they have identified 9 cases that need to be revisited. So we have, and we've sat and met with them earlier this week to discuss what it is that we have. And so, yes, whatever it is that is requested, we will, work with them to see what we have now, so that we can, if we can do it, we will do it.
Any additional questions for the lab? Okay, thank you. Westchester County Department of Labs and Research Division of Forensic Toxicology is next. DCJS and A&EB have been notified of an unexpected proficiency test result for acetone. Acetone was outside of the PT provider's acceptability criteria and was graded as unacceptable. Isopropanol was also an expected result for this proficiency sample, and while the provider graded it as acceptable, the laboratory felt that the standard deviation for their result was higher than expected. During the investigation, it was determined that there was not consistency among analysts in the type of diluent used in testing for blood volatiles. SOPs were updated in July 2024 to include appropriate diluent for the method. Analysts were asked to review the SOP. For medical examiner cases, 2 additional samples were required to be tested, and all secondary samples were in agreement with the blood results. For 1 DWI case that required additional dilution, the undiluted sample was in agreement with the diluted results. Any questions for the laboratory? Anybody? Okay. With that, we've reached the end of our agenda. Just a kind of another quick thing, you've been receiving these proficiency test reporting forms. OFS has been working to develop a quality issue reporting form as well to help with the standardizing the way that you're receiving your documents. So it will organize, hopefully organize better. You should start to see those in your September materials. So that
ETs have been streamlined, so thank you.
Yeah.
It's helpful. I agree.
Yeah, because it's standard. I know exactly what's coming next, so I like it.
It's a process improvement that the crew's been working on.
The lead documents are getting a lot better.
Yeah.
We're working on that too.
The late or the late?
Yeah, the 807.
All right, well, thank you all today for your participation. Our next meeting will be September 26th. Location to be determined. Do I have a motion to adjourn the meeting?
Motion.
Stephen, a second.
Second.
Michelle, all in favor?
Aye.
Anyone opposed or abstaining? Okay, thank you.
Remember there are no drinks.
Yes.
Consequences.
Thank you and have a wonderful weekend.
Thank you,
And
everybody.
happy
Good
Father's
summer.
Day to all the fathers out there.
Yeah.
Safe one.
Yeah, happy